Good morning and Happy New Year. We're here today to discuss the court's decision that was issued late yesterday regarding the use of unallotment earlier this year in the legislative process. I want to just start by asking everybody to remember how we got into this situation. The unallotment statute is on the books and has been on the books for a long time because the state has an obligation and a responsibility and a need to have a balanced budget and to keep control of spending, particularly in times of crisis. We're also here in this situation, got to this point, because of the Democrats' insistence, continual insistence, on raising taxes and engaging in demands for increased government spending. And so I had to made tough decisions in tough times to balance the budget on my own after they presented those bills, which they knew in large part were unacceptable. So I'm going to continue to fight against increased taxes. I'm going to continue to fight against increased government spending, and I'm going to hold the state government accountable to live within its means, just like hardworking taxpayers and hardworking Minnesota families are doing all across this great state. I think hardworking Minnesota taxpayers have had enough of the Democrats' demands for more taxes and more spending. It has to be reined in. That's what we are trying to do with the unallotment process and with our other legislative proposals and activities, and that effort will continue. As to the judge's decision, I've directed my general counsel to work with the Attorney General's office to take an appeal of that decision as quickly as possible. That decision and previous court decisions have confirmed that the unallotment statute in Minnesota is constitutional, and we simply disagree with this judge's interpretation of the statute. At worst, the statute is unclear in a few respects, and the judge could have avoided weighing into this situation by indicating that the statute is unclear and directing or suggesting the legislature and the governor clarify the statute. Instead, she has now the judge has inserted herself into a political dispute. And of course, one of the long-term dangers of that type of action is to have future state budget debates and discussions be run out of a courtroom instead of out of the legislative process. So that degree of involvement by the court is concerning, to say the least. But in addition, we believe that the judge misapplied and misinterpreted the statute in significant ways. And so that will form the basis for our appeal, and that appeal will be underway shortly. The judge made a number of observations in her decision, one of which is the unallotment statute and use of the unallotment power is to be reserved for times of financial crisis. Well, we have one of a historic magnitude. The state and the nation are facing the worst economic circumstances since World War II, and if we can't use unallotment now, then I don't know how and when we could. And I believe she misinterpreted and misapplied the statute in, as I said, significant and various ways, and that appeal will be forthcoming next week. In the meantime, we'll also be taking a number of other steps, including working with legislators to try to get this resolved, regardless of the future direction and outcome of additional court proceedings. If you look at the unallotment plan that we put into place for fiscal years 2010 and 2011, much of the unallotments do not take effect until fiscal year 2011. So at least for that portion of the unallotments, there would be time for the legislature to engage with our administration and find solutions in the upcoming legislative session without having those unallotments impact the current state financial picture. But there are some of them that relate to fiscal year 2010. In fiscal year 2010, there was about $1.3 billion of impact in total for the unallotments in the current fiscal year. The lion's share of that, about $1.1 billion of it, is in the form of school payment deferrals. Now, on that point, the other parts of it, by the way, the smaller parts of it, is about $100 million or so in local government aid payments and also about $100 million in what I'd call miscellaneous health and human service payments, some of which involve counties. But the vast majority of it is in the form of the school payment deferral. On that point, that is something that the DFL legislature and Republican legislators, many of them, as well as our administration, agreed upon. In fact, that was in one or more of the Democrats' proposals this past legislative session. So they signaled both informally and formally that they support that as part of a budget solution. So today by letter and next week by meeting, we'll be inviting the legislative leaders to at least take the step to address and stabilize the outlook for this fiscal year by adopting or ratifying the school payment deferral that was in the unallotment proposal and which was also contained in the Democrats' legislative proposals that they previously agreed to. There will be other issues that will have to be addressed beyond that, but that one step would address the situation substantially, almost entirely, for fiscal year 2010. So we will be suggesting that to legislative leaders. If they're willing to do that and the court is willing to allow some time, they could simply do that when they come in early February. If that's not possible, we'll consider other schedules and alternatives. But that would be the heart of how we would propose with the legislative leaders to address the situation as it relates to fiscal year 2010. And again, changes for fiscal year 11, which don't start until next summer, could be handled during the upcoming legislative session. If that is unacceptable to the DFL legislative leaders, and certainly they may have other ideas or suggestions as well, but if that's unacceptable to them, then of course we'll have to consider other options. But we'll first turn to them to see if they're willing to agree with us on that substantial piece of this, which I hope that they will, based on their previous support and indication that that is acceptable to them. So with that, I'll be happy to take your questions.
The judge indicated in her ruling that the unallotment should be used only in unforeseen financial crises. And she said this was coming for months. Everybody knew it was coming for months. And therefore, she said, you trod on, I think, the constitutional rights of the legislative process. Can you comment on the unforeseen aspect of that and also her accusation that you basically abused the legislative?
Yeah, we just respectfully disagree with the judge. And, obviously, if you're going to make a decision to unallot, you have to have some knowledge and basis about the situation in order to unallot. And the statute says if the commissioner determines certain circumstances exist, then the governor can unallot. The Commissioner of Finance made that determination. We said that we believe the circumstances existed in May. We indicated that the circumstances would exist in the upcoming biennium, and we waited until the start of that biennium to actually undertake the unallotments. So I don't know what's confusing about that language, but obviously we have a disagreement with the judge. You can't make unallotments unless you are aware of a crisis or a circumstance. We've used unallotment before. We've sometimes have deferred the decision to unallot for many months, pending the ability for the legislature to come to agreement or other circumstances. So the idea that you can only unallot if you instantaneously know of a problem, but if you let it time elapse seems not correct to me.
But Governor, isn't the unallotment we did pretty much because of the inauguration, like veto the revenue bill, not adopting other spending cuts and signing the other spending bills that they perform?
No, the February forecast, of course, signaled a deficit, and this is February of 2009 I'm referring to. The commissioner monitors a variety of other financial and economic data, including cash collections on a monthly basis. He signaled concern and that the circumstances for unallotment may exist. And as that situation unfolded, he said they do exist. And so we signed the bills, most of them, almost all of them. Legislature presented them. We vetoed the tax bill. But this is a situation much larger and much more significant than just, the bills, and that as being the factor. And it's turned out to be true. If you look at the November forecast, all that we were concerned about, which is a continuing and increasing deterioration in the financial picture, has materialized.
When do you expect the appeal to be filed?
Well, there's a number of ways to do that, Don. And in terms of actually filing, it'll be as quickly as possible, but I can't tell you an exact date or timetable. There's a number of potential avenues that we'll be exploring with the court. Could be a matter of days, could be a matter of a couple weeks.
You said preamble that
preamble.
Next week, is next week kind of your goal, or is that?
Well, not to bore you with all the legalese, but there's a number of procedural things that have to be put in place in order to appeal, and that's going to involve some interaction with the district court and maybe with the appellate courts, and we'll have to see how they allow us to proceed before we can give you some indication of the timetable. In my view, this is a very acute situation because the state spends, approaching $50 million a day, and every day that goes by, you reduce options. both for the legislative process and potential future unallotments. And we have a requirement that at the end of this biennium, the budget be balanced. And so as each day, each week, each month goes by, it becomes more and more concerning.
You don't want to appeal directly to the Supreme Court?
We're going to work with the district court and the other parties in the case to get the appeal framed up in the most expeditious and efficient manner. What form that'll exactly take on, we'll let you know shortly.
You don't have a preference?
My lawyer is working on all that, so we'll let you know as soon as we decide.
Governor, what does this mean for the average taxpayer? What would you say to them, this ruling? And also, where would any future unallotted funds come from? Where would that money come from?
Well, the practical effect of this is, I don't think, going to be significant in the current fiscal year because while we have this disagreement with the court, the situation is still going to have to be addressed and fixed, probably in about the same way as we did it the first time, unless the legislature has some objection to that. Excuse me. In other words, as I mentioned, we have clearly, unquestionably, agreement with the, well, I shouldn't say, we have clearly and unquestionably unallotment authority currently, so one option is to simply do it again. That's not where we're going to start. That's not our preference. But so we're going to reach out to the legislature to have them try to agree with that school payment deferral and perhaps other things as they did in the spring.
Do you expect other groups to head to the courthouse now and file one?
Well, they might, Eric, but again, I don't think it's. I would just hope before they do that they understand what the outcome is, because there's not a circumstance where all this money can simply be reinstated. It's going to have to be addressed legislatively or otherwise.
Can you talk specifically about the mechanism for how the people impacted by this ruling will get their money and when can they expect their checks or however they're paid?
Well, again, the bulk of it is in school and county money, and so there's some. Those two, yeah. Well, we'll do that as soon as possible. We've got a court order, and it also may be affected by the appeal. We'll see.
Is it possible for you to hold to your position on taxes, as you stated at the beginning of the comments, and not go over the line as the judge said you did on the unallotment authority? In other words, is there a way to abide by this decision and stick to your guns on taxes?
Well, again, first of all, we're going to appeal, and I believe and hope that this decision will be overturned on appeal and our actions will be affirmed through the appellate process. So we have that prospect and, in my view, likelihood. Number two, regardless of the outcome of that, this situation is going to have to be readdressed in essentially the same manner, either by the legislature or by future executive actions. So the answer to your question is yes, for those, because we have those two pathways, those three pathways.
As this, legal process advances, and obviously there's going to be continued discussion and debate. You're going to try and talk to legislators. Your critics are obviously going to continue to maintain that you are advancing this legal battle as you chose unallotment in order to advance your own political aspirations, specifically in a run for the presidency. Can you comment on that?
Sure. It simply defies all the facts. Was in the Minnesota legislature, elected in 1992, and was in the legislature for 10 years, and have been governor now for going on 8 years. So that's 18 years in which my positions on these matters have not changed. So for someone to suggest it's somehow motivated by some speculation about future political office is simply defied by the facts and record. For 18 years as a legislature, as a governor, I have steadfastly, consistently opposed tax increases, advocated tax decreases, and have advocated strong restraint on spending. And so this is not some new concoction of the last 6 months or a year, and it's simply defied by the facts. And I would also ask you then to apply the same standard to all the Democrats who are running for higher office. I notice those questions don't get asked of them very often.
Governor, how much is this not to unallot? Does that mean you're going to try to get it done in legislative session so you won't unallot before or during?
In terms of the sequencing of events, Bill, we'll take the appeal, but concurrently reach out to the legislative leaders. In fact, we'll do that today by letter, outlining that, at least for fiscal year 2010, since they previously proposed and agreed to the school payment deferral, could we at least do that piece and stabilize the situation for fiscal year 2010? If the court allows it, we can do that in early February. If not, we could potentially consider a half-day or one-day special session just for that issue. So we'll see how that goes. And then if that can't materialize, either because they refuse or reject that overture, then we'll have to consider other options.
How much in legal fees does this cost the state?
Well, we use the Attorney General's office, so the individuals who work on the case and who work on it in my office work on a salary basis, so there's no additional cost.
We got time for one more question, Governor. I got to wrap up.
Judge Gearin said in her motion that you can't use she suggested that you use unallotment as a quote weapon in budget negotiations by suggesting that you may use take executive authority again. Aren't you doing just that?
I don't think the court can prohibit me from speaking about my policy views and policy options as a governor. And again, one of the problematic aspects of her decision is, to the extent this statute was unclear or ambiguous, she could have avoided, through restraint, judicial restraint, getting into the middle of a political fight by simply saying the legislature and the governor created the statute. They can clarify it in February when they come back and reserve judgment on the larger issues. She chose to get in the middle of it, and now you have the prospect of what amounts to political budget decisions being run out of the courthouse, and that's concerning. We have to abide by and respect the decisions of the court. They are an independent and third branch of government that I have a particular appreciation for and respect for. And so this is just a respectful disagreement. The art of law sometimes can have some ambiguity in it. And I think the judge here just made a bad, or I should say a misguided decision. One that we disagree with. It's a respectful disagreement. Well, Bill, if you look at the history of this law, it's been on the books since 1930. It's been used numerous times, including by Governor Perpich post-session, by the way. The judge declares in this decision her understanding of legislative intent. In fact, doesn't say it as her understanding, she just says what it was intended for. The statute in relevant sentence says if the Commissioner of Finance, determines certain things exist, then the governor, can unallot. I don't think that's particularly ambiguous or unclear. If it was, and the previous court decisions have suggested that courts tread carefully when inserting themselves between the other branches of government and to exercise restraint. That didn't happen here, in my view. She dove into it, the judge dove into it with some relish, and I think a better way to handle it would have been to say that the statute is ambiguous and suggest that the legislature and the governor clarify it. But it was within her prerogative and discretion to jump in. She did. I don't think that was the wisest way to handle it, because now you have the courts running, directing, and maybe in the intermediate and long term managing political budget decisions for the other branches of government. I think it's a very unwise step.
Right, last one. Question about the food program and
yes.
When and how those folks will receive the retroactive payment that the judge said they would do. Are you saying that the appeal could hold that up, or you'll seek to lock that down?
That's a relatively small amount of money, Brian. So, I think the program has been not operating since November, so 2 months. And in any event, we will move as quickly as possible to follow the court's direction in that regard.